Excellent. Okay. Good evening, and welcome to a discussion of gun violence prevention sponsored by the League of Women Voters of Colorado's Task Force on Gun Violence Prevention. I'm Rionda Osman. This evening, Rachel Dane from Bridge to Justice will share some of the work that she's done with Extreme Risk Protection Orders, or ERPOs. And her talk this evening is entitled The ERPO Law in Colorado. We're recording this session, and the recording will be posted on the League's YouTube channel. Ms. Dane will answer questions as they arise, so please use the toolbar at the bottom of your computer screen or on the side of your tablet screen to raise your hand, and we'll call on you. Before we start, I would like to remind us all that the League of Women Voters is a grassroots organization that has worked since 1920 to improve local, state, and federal government and engage all citizens in the decisions that impact their lives. The Colorado League was founded in 1928. The League neither supports nor imposes candidates or parties, but we do interact with elected leaders at all levels based on our positions on public policy issues. Our positions are formed after member research, study, and consensus. We're passionate advocates, both women and men, who work to influence public policy issues. And I'm now pleased to introduce Rachel Dane. Rachel is a staff attorney at Bridge to Justice. She spearheads their Pathways from Violence initiative, which is Colorado's first program that provides free attorneys for clients requesting extreme risk protection orders, ERPOs. Rachel provides training on ERPOs to attorneys, mental health practitioners, concerned community members, and the general public throughout Colorado. She's been litigating safety issues for 8 years through her work with survivors of domestic violence and brings a wealth of knowledge about the real-world experiences of people threatened by firearm violence. Rachel will provide an overview of the ERPO law in Colorado, data on how it's being applied, and examples of how it affects the lives of Coloradans. So, Rachel, welcome.
Hi, thank you guys for having me. I'm excited to talk to you guys. I'm a big fan of the League of Women Voters, so I was so excited when you guys reached out. So I have some slides, but I'm a pretty informal, presenter. So if you guys have questions, have comments, please, like Rihanna said, raise your hand. I don't always see them when I have my screen shared. So if you need to just say, hey, Rachel, and stop me mid-sentence, that's totally fine too. This material is a little bit hard to present kind of in a linear fashion. So a lot of people kind of like to jump in and ask their questions when they arise. If that becomes, an issue timing wise, I might change things up and say, let's hold questions till the end. But as it stands now, let's just have a conversation. And so I do have some slides to help kind of guide our presentation. Let me share them with you guys. Awesome. So a little bit about Bridge to Justice. So our organization is a 501c3 nonprofit. So we're a charitable legal services provider. We provide services to our clients through a combination of pro bono, so that's grant funded, free to the client work, and low bono resources. So when grant funding isn't available for a certain type of law, we still are able to provide services at a severely reduced rate. So family law, for example, in Boulder County, an attorney costs an average of $350 per hour. We provide services at $125 or $145 an hour when grant funding isn't available. So we do kind of fill a gap between people that don't qualify for legal aid and they can't afford an attorney. So we have our newest program is funded through the Office of Gun Violence Prevention. That's the Pathways from Violence initiative. That's where we represent people seeking extreme risk protection orders and we consult with them for free. I oversee about 60 civil protection orders through a local shelter in our area. We do eviction defense, public benefits, and family law work at Bridge to Justice. And in the slides, I don't know if you guys will have access to them, but our website is the best place to contact us if anybody needs our services. So let me dive in to give you guys an overview of what extreme risk protection orders are. A lot of people call them red flag orders. That is, they're referring to the same thing. And you'll hear me use the term ERPO. It's just a little easier to say. It's just the abbreviation, right? So a little bit of background on Colorado firearm death statistics. One thing that we know about gun violence in Colorado is that the rate of gun deaths has increased. It's increased 42% from 2012 to 2021. The vast majority of gun violence deaths are related to are caused by suicide, but the numbers are going up significantly. So that's something that I was always wondering: is this my perception? Am I just feeling like these things are going up? But the data does support that, yes, it's becoming more common. So what does an ERPO do? An ERPO requires a person who is presenting a danger of committing gun violence. It requires them to immediately surrender to law enforcement all firearms in their custody, control, or possession, and any concealed carry permits that they have. It makes it a crime for them to violate that order. So if an ERPO is in place and somebody, walks down to a firearms dealer and tries to purchase a firearm, they've committed a crime. If a friend hands them a weapon and they take that gun and they hold it in their hand, they've committed a crime. They'd be in violation of an ERPO, and they could be subject to 12 months in jail and a $1,000 fine. Importantly, when an ERPO goes into place, the respondent, right, the person who is posing these dangers, their name will appear in the NCIC database. So if they walked into a licensed firearm dealer and they tried to purchase a weapon, and the dealer's doing what they're supposed to, they would run a search in this database, the name would show up, and they would not sell that person a firearm. And so a lot of people, when they think about protection orders, they think they're pretty simple. In reality, these are not simple, easy things to get. For a typical ERPO case, and there can be some variation in the way that people go about them, but this is 99% of cases are going to proceed this way. People have to go to 2 different hearings. And the first hearing is what's called an ex parte hearing. It's just the person requesting the order and the judge. So the respondent, this person who's acting dangerously, is not present. They're not present at that first hearing. If at that hearing the judge grants that first kind of immediate protection order, then law enforcement gets involved. If there were any threats made to specific people, we want to notify them that there's been a threat of violence so that they can plan accordingly. The police are then going to reach out to the respondent, hand that person the paperwork, and facilitate the relinquishment of their firearms. And then after all of that happens, everybody has to come back to court, and that has to happen within 14 days. So this is a very quick process. Everyone comes back to court for the ERPO hearing. So this is the hearing where the respondent is present, the respondent's attorney is there, they can cross-examine witnesses, present evidence. And at that point, the judge will decide if that ERPO is going to be in place for 364 days. So there are 2 orders. There's your immediate 14-day order, and then there's a longer order, which would last an entire year, but you have to go through a lot more process to get that longer year-long order. So what does somebody need to prove in order to get an extreme risk protection order? So this is the substantive legal standard, right? I described the process before. Here's the substance of what a judge needs to find in order to enter an extreme risk protection order. So at that temporary stage, right, at that very beginning hearing, the judge has to find that the respondent poses a significant risk of causing personal injury to self or others in the near future, by having in the respondent's custody or control a firearm, or by purchasing, possessing, or receiving a firearm. So there's a timing piece to that. It's a pretty high burden that you have to meet. You know, there has to be a significant risk. It has to be happening soon in order to get that first 14-day order. When you come back for the extreme risk protection order hearing, you have to prove basically the same standard, except we don't have that timing piece, right? We don't have the piece that it has to be something we're worried is going to happen in the near future. And so that's the language on this slide. There are 3 categories of petitioners in Colorado. See if I can get it good. I'll just do that. Okay, there are 3 categories of petitioners in Colorado. The first category are people who are in the respondent's family or household. Law enforcement can file for an extreme risk protection order, and then community members. So this third category of community members were recently added. This was April 28th of this year. So it's very new that these people in their professional capacity can request an extreme risk protection order. And so we have mental health professionals, licensed medical professionals, and educators. So I analyze cases in Boulder County because that's where I live, and that's where I practice primarily. So I was able to pull 24 cases from Boulder County, and 10 of them were filed by family members and 14 were filed by law enforcement. And this was over the first 3 years of ERPOs being available in Colorado. To qualify as a family or household member, I mean, the statute defines that pretty broadly. I mean, it's anybody who's related by blood or marriage. So this includes in-laws, have a child in common, we're former intimate partners, grandparents, step-parents, grandchildren, step-grandchildren, pretty much anybody in that kind of family umbrella can file for an ERPO. Household members are anybody who's resided with the respondent in the past 6 months. So that's roommates, people who lived in the same house with that person in the past 6 months. Law enforcement can also file. The petitioner can be filed either by an officer, the agency, or the district attorney. They can request a search warrant. They can have representation if they want to. But important when we talk about law enforcement filing is understanding that a majority of the counties in Colorado have declared themselves as quote unquote Second Amendment sanctuaries. So this means something different depending on which organization was making the declaration. But here is a map I found on the internet. I haven't verified this, but you know, it's a lot of places are reporting that this is accurate, that it's a majority of the counties. And this was as of 2021. So the counties in blue were counties where you have county commissioners, law enforcement departments, officers declaring their Second Amendment sanctuaries, which means either they're saying they're categorically not going to file for ERPOs, or they're not going to serve them, they're not going to enforce them. There's different, you know, are they actually able to do that is another question. But they do have the choice on whether or not they file for an ERPO. And so these, you know, these declarations that they're making are pretty impactful to the people seeking extreme risk protection orders and to the people in the counties who are facing the threat of firearm violence in the immediate future. So there have been some articles recently saying, oh, the Second Amendment sanctuaries, it was all talk, they're filing for ERPOs, which is true. We're seeing a few in those counties, but there's a huge disparity on whether or not law enforcement will file. Oh, sorry. Did somebody have a question? Okay. There's a huge disparity on whether law enforcement will file depending on what county the threat is taking place in. So for example, Denver County, I met with law enforcement in Denver County, and they're very They're very well versed in ERPO. They're not opposed to filing for them. They have a great procedure for instituting, ERPOs, and they're comfortable moving forward asking a judge when they believe it's appropriate to enter an ERPO. And so they told us that in 2022 they filed for 47 extreme risk protection orders that year. If you compare that to El Paso County, a neighboring county with actually a higher population, in 2022, law enforcement filed for 3 extreme risk protection orders. So the disparity in law enforcement action around ERPOs is pretty significant depending on where the threat is taking place. And so, I look at these numbers and I don't think that there's a huge difference in the likelihood of a threat of violence arising in Denver County versus El Paso County. This to me says that this is the attitude of law enforcement when it comes to filing for ERPOs or not filing for ERPOs. And since I'm in Boulder County, I just included our data for a reference. Again, Boulder County is not, a Second Amendment sanctuary, but we do see kind of differences in law enforcement's willingness to file for orders. So, for example, Longmont and Boulder have the exact same population. We've seen 1 case filed by the Longmont PD in the 3 years that ERPOs have been available, and we've seen 6 filed by the Boulder PD. So again, looking at those numbers, to me, that says that this is probably policy or, attitudes about ERPOs within the law enforcement agencies themselves. And so one thing I want to say about law enforcement, so let me walk you guys through what it typically looks like when somebody needs an ERPO. The go-to for a lot of people is to call law enforcement when they have a threat, they have a concern about gun violence being committed by a loved one. Now, not everybody does that for sure, but there are a lot of people that really reach out to law enforcement and say, will you please do something about this threat? And they're hopeful that law enforcement will file for an ERPO. When they talk to law enforcement about their concerns, it's not uncommon for law enforcement to say that they will not file for an ERPO and they're not going to move forward. And then a lot of the people who consider themselves to be the victims of these threats are then tasked with moving forward with the case themselves, which can be very scary and very intimidating for people to go through. So if law enforcement is willing to take on that responsibility of filing for ERPOs, it's significantly better for most people involved in the case. Like the people that have the concerns about violence almost always prefer law enforcement to act, but in reality, they're not acting at the numbers that I personally would like to see. So it's a little bit of background there. And so in Boulder County, I analyzed the different threats that were kind of present in the ERPO cases. And some of our cases had multiple types of threats present, but this gives you kind of a background in the types of violence that these are addressing. So we had 5 threats of suicide. And this is the family petitions, right? These are the petitions where family members had to file themselves. And I'll go into the law enforcement one separately. So in family petitions, there were 5 threats of suicide. There were 3 general threats, and I use that term because I couldn't think of anything better to call it. It was, if I don't get X, Y, and Z, I am going to shoot everyone. It's kind of a general threat. It's not about like a specific person or a specific class of people. There were 2 threats towards specific individuals, and then there were 2 threats for phantom people. So those were typically people who had kind of incurable mental health disorder that was accompanied by delusions of phantom people. And in both of those cases, I think those people also had a history of reckless discharge around their fear of these phantom people. So an ERPO was entered in both of those cases because we were concerned somebody was going to accidentally harm somebody. So it doesn't have to be an intentional necessarily threat that somebody is posing, as long as there is a substantial risk that somebody is going to get hurt by a weapon, by a firearm. an ERPO can be appropriate. And then there were several reckless discharge cases as well, usually accompanied by pretty severe substance abuse. So law enforcement in Boulder County, at least, is significantly more likely to act on threats against organizations and classes. So we had about 5 threats to specific organizations in that 3-year period. These were, I'm going to shoot X location. These were threats of mass shootings directed at specific locations within Boulder County. We had 6 threats against classes. So this was, I'm going to kill all the women I see on the hill. It was very or threats against law enforcement. If law enforcement does X, Y, and Z, I'm going to do that. So those were threats against classes. And then we also had these other, threats of suicide, threats against individuals, reckless discharge, and a few other phantom threats as well. So what this data tells me is that law enforcement is more likely to act when it's a threat against an organization, when it's a mass shooting threat, which I think is pretty intuitive. I think most people would kind of understand that. And so there was one case that had, oh, look at that. There was one case that had a decent kind of synopsis of what it looks like. This was a mental health provider, Boulder Community Hospital, reached out to law enforcement, kind of an example of what some of these things look like in real life. And this person was threatening to shoot, to take guns to specific organizations and threats against his roommate. And this is what they told law enforcement. So someone from Boulder Community Hospital called law enforcement and told me that the respondent, had been fantasizing about killing multiple people with a gun. He told her if he was going to kill more people, he would need a bigger gun. She told me he was specifically talking about people who had wronged him and roommates. She told me he continued to talk about wanting to go to prison for life. She told me she was concerned because how disconnected and unattached from repercussions he seemed. At one point, she told me he laughed when talking about killing people. So this is very disturbing to read. One reason I wanted to talk to you guys about this case is when somebody talks to a third party about wanting to commit a mass shooting or any type of violence, it's not necessarily a crime, right? So if somebody is putting an intended victim in fear of imminent danger, that's a crime in Colorado called menacing. If this individual had gone and purchased the gun, purchased a bunch of ammunition, it might count as an attempt to commit a crime. But just saying these things to a third party is not a crime. So if this conversation had taken place 4 years ago, law enforcement wouldn't be able to do anything about it. Well, they would be able to place him on a mental health hold for 72 hours. But as long as he's saying, I no longer feel this way, they have to release him to the general public. And there's nothing preventing him from walking into a federally licensed firearm dealer and buying the weapons that he talked about in this disclosure. So ERPOs fill a very important gap when people are threatening to commit mass shootings, when they're threatening to harm themselves or others. Those threats don't always fit within a crime. So ERPOs are a really good way to supplement our safety measures for keeping the community safe. So as I mentioned before, community members are licensed professionals, licensed healthcare professionals, mental health professionals, or educators who have interacted with the respondent in the past 6 months. There's also their ability to file when they've treated or interacted with a child of the respondent. So if a play therapist hears a disclosure, my mom is doing X, Y, and Z, and that play therapist suspects that mom is doing that, that therapist can then move forward and request an extreme risk protection order to prevent mom from purchasing guns. One thing to know about ERPOs in Colorado is they are not mandatory. So nobody is required in Colorado to file for an ERPO. This includes mental health professionals, doctors, even law enforcement. They can decline to file, and many do. And then the statute protects that decision. So it indemnifies anybody's decision to file or not file, as long as it's made in good faith. So one thing I've been telling people to consider if you find yourself in a place that you need an extreme risk protection order is that ERPOs don't do anything to protect you. I mean, they're all about firearms, right? And so in that sense, they're protecting from firearm violence, but there's no like stay away provision. There's nothing prohibiting the respondent from retaliating against the person who filed. A lot of people have been asking me, is there a way to do this anonymously? I'm worried that the respondent is going to retaliate against me. And the answer is no. An extreme risk protection order, your name's going to be on the paperwork. There's a way to keep address is confidential. But I think many people are inclined to file for civil protection orders as well as extreme risk protection orders. And that civil protection order is the stay away order. That's the restraining order. That's the they can't come near me or intimidate me or retaliate against me order. I also encourage people to get as specific as possible about the firearms so we know that it's being complied with, right? Safety is always the number one priority. I always tell people don't do this if it's going to put you in any sort of risk. But there are some good resources online. A lot of people who are in a situation where they're considering filing, they don't necessarily know what guns are called, right? And we need that kind of specific information if we need to follow up about violations. So there's this handy diagram that I found on an organization in Florida's website that says, what did the gun look like? How much ammunition have you seen, etc. So let's say that you find yourself in a situation, law enforcement's not filing, and you decide I need to move forward with an ERPO. There are 2 forms online that are fill in the blank. It's really great that Colorado has these forms. They're called JDF forms, and they're really easy to fill out. And filing them in the right jurisdiction has been giving people some trouble. There's a new hotline for that. But the most surefire way is to file in the jurisdiction the respondent resides in, but there are a few other options. So another reason why, Bridge to Justice, why we do what we do, if people are looking to file and they have questions about things like that, they can reach out to us and we'll have that conversation with them for free. And that first hearing, that temporary extreme risk protection order hearing, once the paperwork has been filed, that first hearing has to be within 1 day by law. So if you file in the morning, sometimes it's that afternoon, sometimes it's the next day. It's ex parte, it's just between you and the judge. And Colorado is the only state in the nation that appoints a free attorney for the respondent. So the petitioner doesn't have a free attorney, but the respondent will get one at that first hearing. There's a panel of attorneys in each jurisdiction. They're usually pretty experienced criminal defense attorneys, and they're brought onto the case right away. And then the court will forward all the paperwork to law enforcement. One thing to keep in mind, again, suicide threats are the most common threat that leads to an extreme risk protection order. When we talk about firearm violence, they're the most common type of homicide that occurs. But there's also a group called Means Matter. There's kind of a movement around the Means Matter terminology. And I pulled this quote from the Harvard School of Public Health because I didn't know this until I started digging into ERPO. So guns are more lethal than other suicide means. They're quick and they're irreversible. About 85% of attempts with a firearm are fatal. That's much higher case fatality rate than for nearly every other method. Many of the most widely used suicide attempt methods have a case fatality rate of below 5%. So, so the risks around firearms, particularly as they relate to suicide, can be pretty significant. Also, as I've mentioned briefly, but I want to highlight, extreme risk protection orders are typically temporary. It's not permanently removing firearms from somebody. So when somebody's in a place where they're having, you know, a crisis and their threat of suicide is high, you know, temporarily removing firearms from that situation is the goal of an extreme risk protection order. Okay, so let's say you go to court, you get your first protection order, you get your first order. Service. So law enforcement has to be involved in these cases. The police department in the jurisdiction where the respondent resides will get a copy of all of the paperwork, and they'll reach out to the person filing and they'll say, hey, we're about to give this paperwork and demand guns from this person. Can you tell us, you know, is there anything that you are aware of that it's going to put our officers in danger? In most cases, and at least in Denver and kind of the Front Range, law enforcement seems to be calling the respondent instead of just showing up with the order. And that reason is they've found that it's safer for their officers. So, and it seems to be working fairly well. I was kind of surprised that that's like the approach that law enforcement is taking, but hey, if it's working and it's keeping them safe, I'm all about it. So they'll call and say an extreme risk protection order was granted against you. We're going to be arriving at your residence. You're going to have to hand over your firearms. And they'll have a conversation. In a few super high lethality cases or concerns where there's specific threats against law enforcement, they'll approach it more severely with SWAT and, you know, stuff like that. And there's like bunker situations, but the vast majority of ERPOs are not that kind of case, and this is the way law enforcement's been approaching it. But I'm not aware of any sort of like unified policy in Colorado from law enforcement. I think law enforcement's kind of figuring out how to do this stuff without much guidance. And so that's one thing that we've been considering from a policy standpoint is like, how do we support law enforcement, you know, to make sure that they're doing this in a safe way. Then the relinquishment part. So this is the part that a lot of people have questions. Well, what happens if they don't hand over the weapons, and how does that work? So this is the actual language in the order. It's boilerplate on all of the orders. So it says this order is valid until the date and time noted above. If you have not done so already, you must immediately surrender to law enforcement, and the court will put in the specific agency, all firearms in your custody, control, or possession, and any concealed carry permits issued to you. You may not have in your custody or control a firearm or purchase, possess, receive, or attempt to purchase or receive a firearm while this is in effect. So that puts the respondent on notice that, hey, if you do this, you're violating the law. It's a court order demanding them to hand over their weapons. So does that mean they always do it? No, it doesn't. But there are legal remedies in place if they're not, if they don't hand over the weapons. And so the officers have to, by law, even if they're a Second Amendment sanctuary, the law says that they have to request firearms. So when they serve the paperwork, again, they're required by law to say, I'm requesting you surrender all your firearms. They're also required by law to take possession of those firearms. They don't get to say, we're Second Amendment sanctuary, we're not going to take these firearms. They have to take them into their possession. The respondent has to file things with the court affirming, hey, I handed over all of my weapons. And then they have the option, if they transferred everything to law enforcement, they then have the option to transfer those weapons to a firearm dealer, or in some cases, family, only if it's like a curio or relic. These are kind of like his antique guns and stuff like that. And then the big question, enforcement. What happens? We did our checklist. We went through those pictures. We know there were 5 guns and only 4 were relinquished. What do we do? So the court can say, hey, you didn't fill out the paperwork. I'm going to notify law enforcement and hopefully trigger an investigation. Law enforcement is supposed to provide to the court and the parties a receipt saying this is how many we took into our custody, so that the petitioner can verify, we know there are 5, only 4 got turned over. What do we do next? And this is really interesting, that the petitioner can then request a search warrant. So let's say we have the specifics about that 5th firearm. We know where it's typically kept. We know what type of firearm it is, and we know it wasn't given over to law enforcement. We can file an affidavit asking the court to issue a search warrant, basically commanding law enforcement to go look for that 5th firearm. And then if all that happens, then we're coming back in our 14th day. And so you see there's a lot going on here. So while we're doing all of those things, we're also preparing for our hearing. We're getting our witnesses, our exhibits, everything ready for that contested hearing in 14 days. At that hearing, we have a very high burden of proof. So a lot of people, have concerns because we're talking about a Second Amendment right here. Are these things going to be abused, or everyone's firearms going to be taken away? As I went through, there's a lot of process, right? We talk about due process rights, all of those things I just talked through with everybody. That's process. That's making sure that these things aren't, being abused. And then this ERPO hearing is a big part of that. And so we have what's called a clear and convincing evidence standard. So that's a very high burden of proof. So in law, we have preponderance of the evidence, which is like, it's just more likely than not that this person poses a risk. Clear and convincing evidence is higher, right? It's probably, depending on the judge, it's between 70, 80, 90% chance likelihood that this person is a danger to themselves or others. So we have a very high burden of proof. The respondent's free attorney is there, right? To cross-examine, to make sure that the petitioner is being held to the legal standards. It must happen within 14 calendar days. So this is a very quick turnaround time. So if the court did get it wrong at the beginning, the respondent isn't denied access to firearms for more than 14 days. And most cases do settle. And so what that looks like is most of the respondents will say, I don't contest the entry of an ERPO. And a lot of the cases, the respondents are talking to law enforcement about their intent to commit these threats, or they're talking to a mental health professional, or they're doing things in writing. Especially when there's cases like that, they're just saying, I'm not going to push it. I'm not going to go to a hearing. I just agree to keep it in place for 364 days. And so here's the outcomes we see for the law enforcement petitions in Boulder County. So we had 2. So this is of the 10, and this was our 12, sorry. We had 2 contested hearings from law enforcement petitions. Both were granted. We had 6 stipulations. So those are, those cases where the respondent says, I'm not going to contest this. I agree to this order being entered for a year. We had 3 that weren't really clear. The case file didn't give us any insight into what happened with them, but extreme risk protection orders were granted in those 3 cases. There was one where the respondent didn't even show up to the ERPA. We call that default. And then there were 2 that were ultimately dismissed by the petitioner, and that was law enforcement. What happened in those 2 cases is, in between filing and that ERPO hearing, the respondent did something that was very clearly a crime, and they were able to get the firearms relinquished through the criminal case. And so they're like, we don't need an ERPO in this case. So they dismissed their case. Family member outcomes are very different. We've had 1 contested hearing in Boulder County. The court did enter that order. We've had 2 that were stipulated to. 1 was granted, it wasn't clear. 1 was dismissed for lack of service. Again, that's, they didn't understand. It was family members filing. They didn't understand what they had to do to get that paperwork to the respondent, and the case ended up being dismissed. That's another reason why we wanted our program to be there, so we can help people with kind of the technicalities of the law. And then surprisingly, 5 of those ERPOs were voluntarily dismissed. So that's a huge number of those cases when families file. I went through the substantive legal standard already. And one other thing to mention, just kind of briefly, is that the court can order mental health evaluations as part of an ERPO. So if somebody's not already receiving treatment or they haven't been evaluated, the court can order them to do so. And the court can also order that they be committed. So they be placed on a mental health hold when they're a danger to themselves or others. Just a few other statistics. 6 cases mentioned substance abuse, 6 cases mentioned alcohol abuse, drugs mentioned 5 cases, drugs and alcohol were 2 cases, and then 11 cases didn't have any mention of substance abuse. Almost every respondent was going through some sort of crisis that was mentioned explicitly in the order. So 1 was fired from 2 jobs, 3 were being evicted or otherwise losing their homes. There was a death of a parent, loss of a cherished pet, suicide of a close friend, breakup, land use disputes, conflicts with neighbors, altercations during custody disputes, a terminally ill parent, and expelled from school. So there was a lot of crisis going on with these people that were threatening firearm violence. And that's it. You guys have any questions or comments?
There, I'm unmuted now. Let's see. You were talking about the sheriffs in the Second Amendment protective counties. How do they handle domestic orders, protection orders? Are these the same? Are they the same sort of situations as ERPOs?
That's an excellent question. Sometimes they can be, sometimes they're not. So law enforcement does not have standing, that's the legal term, right, to file for a domestic violence protection order. It has to be either the victim or sometimes the parent of a victim that files for a domestic violence protection order. I can tell you, as somebody who's worked with hundreds of survivors of domestic violence, that we do encounter a lot of the same attitudes depending on the jurisdiction, right? So will law enforcement ask the right questions? Will they continue to investigate? Or are they just going to kind of blow it off and say, I'm not worried? And so a lot of the same, things that we're seeing as attorneys, a lot of our same skills transfer pretty easily to this by saying, yeah, I'm sorry you had to deal with that. The attitude of law enforcement is not necessarily a reflection on your case. So I don't know if that answered your question.
Thank you.
Yeah.
Mary, you have your hand up.
Yes. Early on, it seemed like that in the development of the ERPO law, there was an interim period, like 90 days or something. You only talk about a 14-day and then a 365 days. Is that current law? Is it only those 2 options?
Yes. So there is technically a third option. So for the first order, it's 14 days and it cannot be in place for longer than 14 days. I have seen one case where if the respondent agreed to a continuance, they agreed to it being longer than 14 days, then it could happen. But for purposes of your question, really it's 14 days, then 364 days. And that's really hard in the statute for the most part.
Yeah.
After that expires the first time, the petitioner or anyone else with standing can ask for it to be renewed. So for example, there's been one case in Boulder County where that ERPO has been renewed every year for, I believe, 3 years. I think it's been in place since this became available. And that was because that person does have an incurable mental health disorder, around phantom people, and access to weapons would be very dangerous for that person. So that risk continues year after year. And so they're able to go back and request it. but the judge can order at one of those renewals. They can order 90 days or 6 months or whatever time period they want, as long as it's less than a year.
Oh, okay, thank you.
Beth, your hand's up.
Yeah, thank you, Rachel. This has been really, really good. And I was wondering about funding. I know you said that Pathways from Violence is an initiative under your organization. So, and that part is funded by the Department of Gun Violence Prevention at the state level.
Yes.
So is that your entire funding for this particular initiative around ERPO? And is that a grant or is it a continuing funding situation?
Excellent question. It's a grant. We're hoping that it's a continuing funding situation. The Office of Gun Violence Prevention has been tasked with, funding programs like ours, and we believe very strongly in our program. That's I believe, one of the biggest kind of gaps in implementation of ERPOs. I hope my presentation kind of covered how complicated this can be for people to navigate when this stuff happens, and really the importance of having a free attorney that they can call and say, help me, like, what do we do? Is extremely important to making sure this law is actually doing what it's supposed to do. And I believe the Office of Gun Violence Prevention is pretty strongly in our corner about that. But we are a 501c3, so we do always appreciate donations and support from anybody who's willing to give it.
So one follow-up question to that is, it's the Office of Gun Violence Prevention. Are they also helping to get the word out about the availability of your services for people? Because it seems like that's what this is all about tonight, but I need to get that word out to more people.
So they have an awareness campaign for ERPOs in general. I don't know if they're specifically talking about us as a resource. That's one thing that we've been trying to navigate, because we are, I'm a family law attorney, and I'm trying to figure out how to do advertising and stuff, and I'm not sure that I'm doing it effectively. So that's something we're trying to do, is to spread the word. And again, any advice anybody has for us, we greatly appreciate it, because we do, I suspect there are people out there that really would benefit from our services that just don't know we exist.
All right. Thank you.
John, your hand's up.
Yes, Rachel, thank you for a very crisp and lawyerly presentation. I was talking with I live in Fort Collins. I was talking with some students. Does it ever happen that students can be aware of some potential trouble with one of their peers? And if so, is the avenue to their school resource officers or to school mental health counselors or to school principals? Does it happen, and what are the avenues?
That's an excellent question. So yes, it can happen if they disclose to any of those people. The school counselors and educators would have standing to move forward. One of the problems with professionals filing is there's not perfect protections for them from a liability standpoint. So we're running into a lot of kind of our institutions saying, we don't want to be sued. We don't want grievances filed with us with the Department of Regulatory Agencies. We don't want to have to deal with any of that. So there are a lot of institutions that are being really hands off from it. There's the Safe to Tell initiative, which I believe allows for anonymous reporting. One thing that I've come across a lot in my career, though, with people experiencing violence, and especially young people, is kind of self-doubt, right? And I'm not like this whole, well, would my friend really do it? Like, I don't know that I want to report yet. And one of the things, if we're dealing with people who are under the age of 18, is the mandatory reporting laws. So a lot of people under the age of 18, if they talk to anybody, the mandatory reporters are required to get Child Protective Services involved if there's a threat to children. And so some of these kids, I suspect, don't really have a safe place to turn to like have those conversations of, hey, is this real threat? Is this something I should be concerned about? And so that's one thing that our program could provide, because attorney-client privilege is like way more ironclad than talking to a therapist. And then when it comes to students kind of, over the age of 18, I recently had a case with some, they were just out of college, some young professionals, and one of their friends, somebody in their friend group, had a schizophrenic episode, and they were really concerned about him, and they all got together and they figured out who has standing to file. And actually one of them was an attorney, excuse me, and was able to help them navigate that process. So they were able to file before Bridge to Justice came on. But figuring out, okay, well, am I even allowed to file? Do I meet one of these classes of people? If not, who in our friend group is able to file? Did somebody date this person? Was somebody a roommate? Who's able to file for these? And then kind of coming up with an approach on how to move forward with an ERPO in those situations is really daunting. But yes, there are options available. Kind of figuring out who the person who's going to file the paperwork is a hurdle, though.
Rachel, you mentioned mandatory reporting. If under 18, you said mandatory reporting kicks in. Suppose, were you referring to the report by an underage child about his concern or her concern of another person, or were you referring to an underage child talking with a counselor or school principal?
Good question. So a school counselor, principal, therapist, anybody with those kind of licenses is required to report to law enforcement or child protective services when there's a threat to children's safety. So let's say, you have a junior in high school whose friend is saying something concerning and they talk to a school counselor. That school counselor is required by law to report that threat to law enforcement. So if you have a teenager who's like, I don't know if I want law enforcement involved yet, I'm not comfortable, like, what does that even look like if I do tell somebody about this? Creating a safe and confidential place for them to have that conversation before they move forward with getting law enforcement involved, I think is one area that our program would fill a gap there.
What does that look like? The safe and confidential area for a student that lives in Fort Collins, who would, your services are available in Boulder County. Mm-hmm. Is there a comparable source in Larimer County?
Good question. We do take cases in Larimer County. And so we take cases anywhere in Colorado if we have attorneys willing to travel to that location. So we have specific funding under this iteration of the grant to take cases in underserved populations and underserved areas, not just along the Front Range. So, and Bridge to Justice, one of the things we do too is we operate as a clearinghouse. So if somebody contacts us and we're not able to help them, we never let them leave empty-handed. We get them connected with organizations in their area or a specific list of people to go to.
So if I happen to talk to a 17-year-old with concerns, I could give them the name of Bridge to Justice as a reference for them to then go with their concerns?
Yes. And our website is the best place for people to go. There's a form on our website. We have a special screening procedure for safety issues like this. So if somebody has a danger concern, they get into our program very quickly. We try to get them connected with an attorney like as soon as humanly possible. So yeah.
Do students under 18 students ever find it functional to go to the parents of a friend about whom they have concerns? Is that a common and useful avenue?
It could be. That's a complicated question because we always have to do safety planning in conjunction with our kind of legal planning. So, my questions to somebody like that would be, what do you know about the parents? Do you believe they're likely to move forward with something? And if they don't move forward with something, are you worried about retaliation? And so how do we protect you in case that doesn't go the way we hoped it went?
Okay, so the first resource is Bridge to Justice and the advice from professionals about how to proceed.
Yeah.
Okay, thank you very much.
Oh, I have another question. Right now, your funding comes from the State Office of Gun Violence Prevention. Now, there has just been installed a federal office. Will you be able to tap into them for support? Is that a plan?
Now that I know about it, yes. Honestly, I didn't have it on my radar. But yes, absolutely. I think that I'm really proud of our program. I had a similar program for domestic violence protection orders that I've been managing for 7 years. 6 or 7 years, I kind of lost track. And so we're copying a lot of the things that we've seen work really successfully in the domestic violence sphere, right? A lot of our skills transfer very much, and a lot of the things we've seen work, people facing violence, it's very similar situations to domestic violence. And so copying that, we're really proud of our program. And if it works well in Colorado, and I believe it's working very well, then, I want to tell the whole world about it because I think it's a good resource.
Okay.
But yes, as far as funding goes, we will pursue, whatever avenues are available to us for sure. I mean, we're a small nonprofit. We need, everything we can get.
Okay. Beth, your hand's up and you're muted.
Yeah, I just wanted to ask, thinking about your program, and how many attorneys, you said you have some pro bono, some low bono. And obviously you're one of the lawyers, but how many are on your staff, or do you have?
Well, we have a combination of staff and contract attorneys. So our staff attorneys, we currently have 4 staff attorneys right now. We're going to be hiring 2 fellows. So we have a new domestic violence program that's going to be launching in January, and we're going to hire 2 fellows that we're going to teach how to be trauma-informed, DV-informed attorneys. So we're going to be expanding. But we have our contract panel for the domestic violence program has about 10 attorneys. Our contract panel for the eviction defense, so Boulder has no eviction without representation, and we do pretty much all of those cases in Boulder County. And so we have a panel of, I believe, 4 or 5 attorneys, the contract attorneys that do that work. So there are a lot of people who, are these great civically minded attorneys that don't necessarily want to work for a nonprofit full time, that will take a few cases, and we partner with them that way.
Thanks.
Okay. Anyone else? John, your hand's up again and you're muted.
I must thank the League of Women Voters. I'm privileged to be here, is how I feel. A month ago, we had Dr. Barbara Kingston, who has a community safe school program out of CU Boulder, and I forget the exact name of her Institute for Statistical Studies of Violence Prevention. Do you know Dr. Kingston, her program? Do you have any contact with that program?
I do not, but I would absolutely love to reach out to her. I did a presentation last week to the Metro State Licensed Clinical Social Worker program, their Masters in Social Work program. And so I got to talk with some mental health professionals, but I'm talking to anybody and everybody who will listen to me right now. So I appreciate any leads that you guys can give me.
Well, I will send you coordination with Beverly Kingston. She's with the Institute of Behavioral Science at CU.
Thank you.
Okay. Anyone else? Well, thank you all for being here. Rachel, this has been very, very informative. Thank you. And best of wishes for this good work that you do. Thank you.
Thank you.
So, bye.